And welcome back to Jeff Koinange Live here at Citizen Television, here with two brilliant lawyers who happen to be legislators as well. The Deputy Speaker of the National Assembly, Gladys the Boss, is in the house, as is Dr. Otiende Amolo, Senior Counsel, also MP for Rarieda, talking about the way forward between the executive, the judiciary, and the legislature. Folks, before we get to the dialogue between, the supposed dialogue between the executive and the judiciary, let me ask you this, boss. Is there any merit to President Ruto's complaints that the judiciary is stopping his projects?
Of course, when the matter went to court, we had the Attorney General together with the Council on behalf of the government. The government had taken a position. So yes, it did stop the projects. Affordable housing is one of them. I know we have also a court case relating to the Social Health Fund. Mm-hmm. Yes.
Senior Counsel, do you agree?
Of course, I don't agree.
You don't agree that it has stopped?
No. The question should not be whether there's merit in saying the judiciary is stopping some of his project. Of course, the judiciary is stopping some of his project. The question should be whether they have been stopped legally and legitimately. Mm-hmm. And the answer is yes. The bottom line is not that question. You see, even today, the president could make it his project to sell the whole of Nyanza province to Saudi Arabia. It can be his project. If we went to court and the court stopped that, will they complain that the court is stopping the president's project? The question is the legality and constitutionality of that action. And if you rephrase that question, therefore, the issue should be this. Is it true that the courts have been unfairly making decisions to the detriment of this regime? The answer is no. In fact, if we were to examine it, Jeff, look at the last 5 years. The decisions that the courts have made are decisions that are beneficial to William Ruto and this regime. Even before he was elected president, Uhuru Kenyatta and Raila Odinga had that BBI project. And I'm the first to agree that it had constitutional issues. I even raised them in parliament. Again, it was not listened to at that time. The court stopped it to the benefit of William Ruto. Did he complain that the courts were corrupt? No. When we came to elections and we went to the Supreme Court and we wanted the Supreme Court to do certain things, including open the servers and all, and they didn't, they made a decision in favor of William Ruto to a great detriment, using actually unpalatable and unjudicious language.
Like hot air?
Yes. Like wild goose chase and other things that judges don't usually say. Did he complain that the Supreme Court was corrupt? He didn't.
No.
For the last 1 year, I want you to, and if we had time, I would give you the full list. Look at the list of people who are within William Ruto's regime, either from the deputy president to ministers to MPs who've crossed over to his side to people appointed to cabinet, who had criminal cases, all of which have been terminated. Those who had monies frozen have been given back to them. Did he complain that the judiciary was corrupt? No. Indeed, William Ruto himself even has a case of Weston that has been in the courts for the last 5 years, has not been heard, at the request of his advocate, to stall it, hoping that he would be elected, and eventually is elected. Your guess is as good as mine where that case will go. Has he ever complained? No. So the question is this. Indeed, even internationally, if you look at the ICC, if the ICC, which is a judiciary, was corrupt in that sense, who benefited? He was an accused person. Most accused persons are never allowed to stay in their countries as the case is going on. He was allowed to be here, with the result that witnesses disappeared, some were intimidated, the case was terminated. Did he complain? So there's no foundation for complaining, except that now, when the judiciary applies the same laws to stop what has not been done constitutionally and legally, then they now turn and say he's stopping the project. Do you realize that even since we started this debate, Madam Shule has not even alleged that the affordable housing scheme or the health scheme was done constitutionally? She has not, and for good reason, because the soundness of the decisions is difficult to attack. So you leave the decisions and you go to public opinion and say, this project is being stopped, this project, without disclosing to them that is the process. It's like BBI. Eventually, even we were dissatisfied And in the court of public opinion, those who are dissatisfied generally did not care to explain that, the court said that the process was faulty like this. So when you can't explain it legally, you appeal to the emotions, and that's what they're trying to do.
Okay.
First of all, I mean, he knows very well, he's a senior counsel. In most of the time, we agree with a lot of the decisions by the judiciary. But there are other times when we have questioned the judiciary. And he can tell you, even in his own practice, there are many times you have not agreed with the judiciary. So there is nothing wrong with disagreeing with the judiciary. That is why we end up having a court of appeal and a Supreme Court to be able to appeal that decision. Because sometimes when a decision is made by one judicial officer, you can go and question it by going to a higher court or asking for a full bench. So this is not abnormal.
Yes.
But the messaging that is coming out, it's like nobody should ever say anything about, or that you cannot disagree with a judgment. We have disagreed with it.
Yes.
And even the legal soundness of that particular judgment, we have a problem with. Another challenge that we've had with it, that personally as a lawyer, is that it is not logical for a judicial officer to give ex parte orders against the government without hearing them. Why not say go and serve the Attorney General and come back to court in 2 days, and then both sides can be heard and they can make a decision. So it's some of those challenges that we are questioning.
Now let me just correct.
And you are and
yes, I actually agree with you to the extent of saying there's nothing wrong with disagreeing with a judge on a decision. I agree with you completely. But that's not what's happening here. Jeff, in law, there's nothing wrong with criticizing a judgment. You can take a judgment and write an article on why it's wrong, word by word. There's nothing wrong with that. Critiquing a judgment is legitimate and is not contempt. But going to critique the person of the judge, that's a different matter. And that's what they're doing. They're not going for the judgment. They're not taking that decision and analyzing on why it's wrong. They are going for the judges who made the decision. That's the first reason it's wrong. The second reason why it's wrong is this. Even when you critique a judgment, like we did in the Supreme Court, and we did it robustly, you must still accept that that is the decision of the court and you must abide. You do not have the leeway, as William Ruto is saying, of saying that he will not respect decisions that are unpopular in his own opinion. He is becoming more learned than all the judges. It's actually ironical because the judiciary is to check on the executive and is the head of the executive. But now he wants to arrogate himself the role of checking on the judiciary, like a prisoner wanting to determine for the prison's official how to keep the prisoners from escaping. That's just nonsense. Lastly is this. When it comes to logic, and this is why it's so ironical, and this is why I'm telling you that this regime wants to take us 40 years back. When Madame Shulei, who is a brilliant lawyer and knows all this, in fact, she is the one who even started the law reporting docket in this country. So she's aware of all those decisions. She knows that there are cases where you have to go to court and get ex parte orders against anyone. It cannot be that you are telling the court that you cannot issue ex parte orders against the executive. I mean, everyone is equal before the law, whether you are the president, whether you are the executive, whether you are an ordinary person. The same way, the courts issue ex parte orders routinely. For example, if today the EACC think that you have some monies that is stolen, they will not come and serve you. They will go to court and they'll get orders to come and search your premises, your office, to freeze your accounts before they serve you, because if they do, they will not get that money. So they want, and in fact that statement betrays what they want. They want to intimidate the judiciary not to issue any orders against the executive, ex parte or otherwise. That is the bottom line.
That is the bottom.
Okay, you know very well, as a senior lawyer, he knows this very well. Giving an ex parte order is an extreme measure, because you're giving an order without hearing the other side at all. It's not something to be dished out without too much thought. It's a very dangerous, it's dangerous to do it. So you must really reflect and say, is there going to be, and we know the rule is always that unless you give out an ex parte order when you know that there's going to be irreparable harm and damage, should you not give out that ex parte order? In these cases, what was the irreparable harm and damage? There wasn't any risk.
Of course there was, and I can explain.
What was the risk?
The point is this. First of all, in the eyes of the Constitution, they are just parties to a case. There is no party who's superior because you're in the executive or in the legislature or wherever. You are all equal. So you cannot start saying that you can give ex parte orders against a citizen but not against government. That's just, with
that's
respect...
not what I've said.
No.
Ex parte order should be given where there is, irreparable harm and damage.
No, I'm coming to that explanation. Your first explanation...
Case, what is the irreparable
I'm coming to
harm
that.
and damage?
Your first argument was that they are giving ex parte order as against government. That was the first. Now, let's come to the second, that they're irreparable. Look at the affordable housing scheme, for example. The bill was passed in Parliament, despite our objections. It became law. It was signed the same day, with the consequence that citizens were being made and are still being made to pay money. They're being taxed without a legal basis. Now, look at that. If you are a judge and you're faced with that, where people are being taxed, yes, in a way that is unlawful, and when you find it's unlawful, there is no way of returning that money because they are being taxed in a way that it doesn't come from the pay slip and in a defined manner. Or you delay it so that you determine whether it's constitutional, and if it is, then it will be paid from that day forever. Where does the balance lie? It lies in favor of saying, hold on first. Let's look at the legality before you start taxing Kenyans. As it turned out, there was no legal basis. And their own action actually validates that. To tell you the truth, I don't understand their complaint. Look, the affordable housing scheme, and to disclose, I was the lawyer, I was the advocate who was leading the team, pro bono. The court says that you did this unconstitutionally because there was no legislative basis. They now say the court was wrong and they have appealed. That's on the one hand. So they believe that decision was wrong. On the other hand, they are agreeing with the decision and they've already drafted legislation which is now going through public participation to enact the very thing and do the very thing the court had advised. So they're trying to probate and reprobate. You can see that they don't even know what they want to do. If they believe the court is so wrong, they have no business passing that law. They should appeal and hope it's overturned. Okay. But if you accept they were right, apologize and then restart the process.
Okay, there's so much legalese in here, I'm getting confused. Okay, dialogue talks. President has indicated he's willing to speak to Chief Justice Koome and the judiciary. Azimio leader Raila Odinga says, no way should they meet. What's going on? What's wrong with dialogue?
There's nothing wrong with dialogue, but I really haven't followed what Raila Odinga was against. Because even Raila Odinga himself has been the biggest critic of the judiciary. When BBI decision was made, he has been known to call the courts Kotibandia. I mean, so really, he's not the person to be speaking about this issue. Yes.
By the way, he says it's a ploy by the executive to lure in the judiciary if they meet. That's what he was saying, right, Senior Counsel?
No, but you know what? Where the influence on the judiciary should not happen is in their judgment making. So nobody is going to have a dialogue with them to discuss how they should make the decision. That they will always do. And in fact, if they don't follow the law and make the decision independently without fear or favor, that can be a ground for their removal from office. So no one is interfering with their judgment making. Yes.
Yeah.
Should the meeting happen?
First, I am not sure, and we were discussing with Honorable Shelley here, the basis of that statement that the CJ has invited a meeting. Because I read the statement that she read on behalf of JSC. I did not see that. But I admit, perhaps, because I did not watch the actual interview, perhaps she may have made that off the cuff. Now, if she did, and I was asked this yesterday morning, and I was of the firm view that there's no basis for dialogue, and that would be the wrong direction to take for three reasons. First of all, the Constitution. Article 1 and Article 160 lays a very clear basis of separation of powers, okay? The idea of that separation of powers gives each of these governmental arms a distinct role. And even if we in Parliament, for example, were to disagree with the President, the process is this. We pass legislation. If the President thinks that it's not right, then he returns it to Parliament with comments. If we in Parliament insist that the President is wrong, then with a 2/3 majority, we'll still pass it anyway. Right. For anyone to suggest at that point that what we should do is dialogue is to try to break the walls of separation of powers, to merge the legislature and the executive and the judiciary. The idea in the Constitution is that they must check each other. And when they do check each other, you don't need conversation if they do it properly and constitutionally. Article 160 says the judiciary will not take control or direction from any person. To seek dialogue, to talk to the judiciary about execution of their duties is to seek to control them and direct them. That's number one. Number two, under the Constitution, there's a clear mechanism. If you think that the judiciary is not doing what it ought to do as a body or an individual judge, that's why we have the mechanism of the Judicial Service Commission. And it's not just the Judicial Service Commission. We have other independent commissions that can also act, including the Ombudsman. If you think so, you don't call for dialogue. You invoke that avenue. Quite honestly, if it were to turn out that there are 2, 3, 10, 20 judges who are corrupt and the President knows it, then he is actually acting unconstitutionally. He is not protecting the Constitution. It is in our collective interest to smoke them out through those processes and deal with them. But what they are seeking to do is to say, now we are ready for dialogue with the Chief Justice. The Chief Justice cannot even hold dialogue because the Chief Justice, as CJ, cannot hold dialogue with the President on the direction the judiciary should take on decisions. It would be the Judicial Service Commission. But even the Judicial Service Commission cannot control individual judges on how to make their decisions. In fact, you'll be surprised, Jeff. Do you know in law, and it's written in the Constitution, a judge is allowed to even make a wrong decision in law, provided they have made it in good faith. Yes, they're allowed. So you can't start holding decisions on how a judge should make a decision. If it's in bad faith, smoke them out. What this would amount to is wanting to be a judge in their own cause. The judiciary is supposed to oversight you, but now you are calling for a meeting where you are chairing to discuss with the judiciary how to oversight you. It's like somebody coming to your house, they want to throw you out, and then they say, now you come, we talk. No, you throw them out first. People can talk, and that's what the judiciary must do. No. Reject these overtures.
No, I think where we are going now, you're speculating. You know, nobody knows what the content of the dialogue is or what it was meant. Yeah. Like we said, I didn't see it in the CJ's statement. So all we are doing now is just overstretching our imagination and beginning to just whip up emotions as he's saying that, oh, the President wants to preside over the judiciary and tell them what to do. He knows very well that every judge, in fact, the Chief Justice cannot even direct a judge on how they can make their decision. Neither can the Judicial Service Commission. Each judge will independently address themselves to the law and look at the law that was argued before them, the precedents that have been brought before them, and other authorities, and make that decision by themselves. So it even doesn't make logic for you to try and stretch your imagination and say that the dialogue is to direct the judges.
Precisely.
That has not happened.
No. Because there is no basis for dialogue at all. You know, President Ruto is trying to make the same mistake Uhuru Muigai Kenyatta made, and I made this comment, when he refused to appoint certain judges on account of having some dossier against them. Right. I firmly submitted that the President does not have such discretion. If he has such discretion, once the Judicial Service Commission recommends a judge, first, you should submit it in the process of recommendation so that they are not recommended. But if you withhold it and then they recommend that judge, then your only leeway is to appoint that judge. Once they are appointed, unleash what you have to the commission, then the judge can still be removed anyway. Now, that is the mistake William Ruto is trying to make here again. There are certain things you cannot fight, like the constitutional provision protecting judges. You must just follow the law as it is. There is nothing to dialogue. If it's corruption, how do you dialogue over corruption? If he says that there are judges who are corrupt, how do you start dialoguing with the Chief Justice to tell them that now, tell that just to be less corrupt? No. Give the evidence for their removal.
That is just speculation, because you're the one who are saying that there was a discussion about dialogue. We don't know if that is in fact has happened or whether it was alluded to. So
the president is on record as saying there are corrupt elements in the judiciary. Yes. He has not made any other complaint. Right. The only other one you've made here is that the judges are making decisions, frustrating policies of government. How do you start discussing that? That now tell your judges not to frustrate policies of government? Surely.
Nobody has said that will happen.
I'm glad you brought up the question about the 6 judges who were appointed by the president soon after he was sworn in, right? Former President Uhuru Kenyatta had refused to appoint them for the longest time. So let's take a break, and when I come back, I'll ask, what went wrong? I mean, the president started on such a positive note. The judiciary was like his best friend. What happened 13 months later is what we want to know. Let's take a break. This conversation is smoking hot. I tell you, when we get Senior Counsel Dr. Otiende Amolo in the house and Gladys, the boss herself, you know it's going to be a great conversation. What are your thoughts? We'll go to the magic wall as well when we come back. At Koinange Jeff, at Citizen TV Kenya, the hashtag JKL. JK Live takes a break. We'll be back in a moment.